Doesn't look like the jail's on.
Ms. Beckman is appearing in person for the state.
Your Honor.
Yes. Yes? Somebody asked me a question, but they're not answering me.
I apologize. I'm having some internet problems. Ms. Peters will be coming on. She's on another Zoom hearing right now, and the interpreter just signed on.
Okay, great. My JA is going to go ahead and contact the jail and see where we are with Mr. Massad, because I don't want to begin without him.
Okay.
Can we begin without Ms. Peters?
Yes, we can, Your Honor.
Okay, great. I'm just going to ask everyone who isn't a party to the hearing to make sure you're on mute. So I don't have to mute everybody and then unmute. But I see all my press people already muting. They're good at this. I have nobody waiting in the waiting room, so. You just came on. Jail's checking, seeing what's going on.
What, you come in? You can get it out. Yeah, you told me that on the phone. And that's fine.
Just so everyone knows, the jail's having a little computer issue. They're saying 5 minutes, so we'll just all sit here and wait. So, while we're on that, Mr. Broomvon, I can talk to you about your pretrial.
Yes.
It's on the other case, which is 19 CF 4273. I think we are agreeing to reset that pretrial for November 10th at 9 for your other client.
Yes, that would be
Okay.
great.
The
Thank
clerk's
you.
here, so they'll go ahead and do that.
Very good. Thank you.
Just so you all know, just if you haven't seen it, the administrative order from Judge Rondolino and the operational plans for the Sixth Circuit that were filed and I think became public record yesterday or the day before indicate that jury trials can begin on or after October 26th. So I don't know if you all had seen that or aware of that. But that's the date where we can start picking juries.
Was there any indication, Judge, that in the beginning, when we first start going back to trials, whether we will have to social distance and mask?
We will have to both social distance and mask, but we already have my courtroom set up. So most of the proceedings, if you are speaking, you will not be masked. You'll have to be masked when you're not the person speaking. So I've already done a couple of hearings, bond hearings and whatnot in my courtroom, and I have it distanced out. So if someone's in the witness box, they can remove their mask because they're more than 12 feet away from both the jury or the people asking questions. They're 6 feet away from me. So if they're in the jury box, I wear a mask, or if they're in the witness box, I wear a mask, but most of the time I don't because I'm more than 26 feet away from everybody else. So yes, there will be masks. Yes, there'll be social distancing. We already are marking out my courtroom with X's where people can be, but all of that is being considered. There's also rules where people can require or request a 6-month deferral to be sit as a juror. And those are all from the Supreme Court. So yes, there'll be social distancing and mask, but we have it all set up, so.
Got it.
Will you let me in?
Oh, they're waiting to be let in. Hold on. You have to turn your microphone off,
I will.
okay? I don't want to let you in till you do that. You off?
Oh, which,
Oh,
so
so
it's
I messed.
yeah, it's off.
Okay.
Yeah, it's loud. If you don't.
All right. Let's see where we are so far. They're getting, Ms. Beckman, you're coming in, and I think that's the jail that's coming in. I have Mr. Massad. Can you all see him?
Yeah, I can see him.
Yes, Your Honor.
Is there a need for him to keep a mask on?
That's the jail rules, not mine.
Okay,
So,
okay. All right, we can begin.
okay. All right. We're here on originally was set for a sentencing on Mr. Massad's case on case number 19 CF 1580. We're also here on pretrial for the other two cases, which are case numbers 19 CF 1154, which is currently set for trial on October 5th. That's the one with the state attorney. And then 19 CF 1155, which is the statewide prosecutor's case. As I indicated, I did have a conference call yesterday with the statewide prosecutor and Mr. Broombond, just to let them know that based on the update that we are allowed to have jury trials, that I was going to go ahead and cancel the sentencing set on 19 CF 1580 today. And my thought pattern on that was, the reason I said it was because when we said it, there was no indication that our circuit, the Sixth Circuit, was moving in any manner whatsoever through phase one where we could get to phase two. We were able to finally get everything worked out. The numbers, more importantly, went down in our counties, both the Sixth Circuit in Pasco and Pinellas. And therefore, the entire circuit has moved as of September 1st from phase one into phase two. Phase two, we have to stay in phase two for 30 days under the Supreme Court order, and then we can begin to do jury trials. The Chief Judge, Judge Rondolino, authored an order and an operation plan, which was published and is public record, that jury trials now can begin on or after October 26th of 2020. Who can be tried, what cases can be tried, and under what requirements they would be done is specifically left to the administrative judge in each circuit within the county. So in our county, that would be Judge Sean Crane. Clearly, Judge Crane and I agree that the case with the state attorney's office, which is 19 CF 1154, which has multiple counts of attempted homicide of a law enforcement officer and has a lot of people testifying, would not be one of the earliest cases to be tried. However, the other case, which is the statewide prosecutor's case, which is the practicing medicine without a license, 19 CF 1155, is all third-degree felony cases. And from my conversation with the statewide prosecutor yesterday, the amount of witnesses would be around 4 or 5. And if statewide, if you'll back me up on this, they indicated to me yesterday they thought that that case with jury selection would go approximately 2 days. Statewide, is that what you told me yesterday?
That is correct, Your Honor.
Now, Mr. Broombaugh and Mr. DeFlaming, I am sure you've discussed this since then, because Mr. Broombaugh had not discussed this with you or Mr. Massad yesterday, of course. That's why I gave him the heads up so that he could have this discussion. There was no indication from the defense side whether you would have additional witnesses, other than, of course, Mr. Massad if he chose to testify. And or most of your case would be cross-examination, impeachment, whatnot, with or evidence in the form of exhibits on the defense side. So, Mr. Broombaugh, did you get a chance to speak to Mr. DeFlaming yesterday or today about this?
We spoke, and I believe Mr. DeFlaming would like to take the lead on discussing our discussions.
Okay, I just know I don't want to go into your discussions. I just know that we had that meeting off the record yesterday. Yes. So I'm just trying to kind of lay the record that I'm not trying to hide anything from anybody. I just wanted to make sure you had an opportunity to speak to Mr. DeFlaming about that. And what I had said yesterday and what I continue to say is that I am willing and able to place the practicing medicine without a license case on the trial docket with coordination through Judge Crane as soon as after October 26th as possible. Now, there was some indications that, one, you haven't done a lot of discovery for that case. I don't know how much there is to do, but again, I'm not you, and I don't know how you do your job. So I'm not telling you how to do your job. And number two, that may not be the case that you want to go forward with. The point that I was trying to make, and I continue to move in that direction, is one, Mr. Massad does not score mandatory state prison on the case that he's been convicted on. However, if he is convicted of any one of the counts in the other statewide prosecutor's office, he would move from a non-state prison up to 5 years category into a mandatory state prison category. And therefore, the court does not feel it would be appropriate to sentence him now and then come back when he's been in custody all this time and then let him out to come back, to go back to prison. It's the statutes and the case law seem to indicate that the court shall have all of the cases together when they sentence. So my point being is I can move in a very expedited way to give him a second trial. And the statewide prosecutor's office has been the one that is not in favor of any release or any agreed upon bond release. The state seems to indicate, or has been in other court hearings, that they would be willing to let him be released pending their trial. So I'm trying to work through all the different things that are going on, cases, prosecuting authorities, what people have agreed to, what people haven't agreed to try to move in a way that's best for Mr. Massad. So, Mr. DeFlaming, that's a long way around it. Where do you stand on that?
Okay. Judge, let me begin by saying that Mr. Massad is extremely disappointed. He and I had an opportunity to talk this morning, and I kind of share his disappointment. The last time, as you remember, we had a Zoom hearing. Court made the decision, and I understand your reasoning now, to go ahead and set a sentencing. And at that time, you indicated that you would readdress his issue of release on bond. Now that it appears as if the sentencing is not going to go forward, my suggestion is this. Based upon the previous discussions, you've heard enough about the bond issue. I think the court is probably in a position to make a ruling on that. If you were going to reconsider it, there's nothing new that has happened. My suggestion is that both of these cases be put off. They're both going to be multi-day cases. Although I appreciate the statewide prosecutor saying this is a 2-day trial, we haven't even taken depositions. And once we do, we will file our witness list and we will file our evidence list. And it'll have to do with medical testimony and so forth in the event that they claim that in any way my client harmed them medically. So both of them are going to be substantial trials. So what I'm asking, and I say this with the approval of Mr. Massad, is that the court proceed today on the issue of release. Let him go home during the pendency of this COVID problems. COVID is now solidly in the jail, that he be released on any conditions, and we've had very, very strong conditions for his release, and that we go ahead and try these cases not in a hurried fashion, but that we try them in the very beginning of 2021 when everybody's ready.
Okay, statewide?
Your Honor, our position hasn't changed since yesterday. The case can go forward. It is not a major case in the sense that the other case pending against Mr. Massad is. And we feel we can be prepared within the 60-day window Your Honor discussed yesterday. We certainly do not agree to the release of Mr. Massad. He is a convicted felon. He has not been sentenced. There is no basis to be releasing him on bond simply because he has not been sentenced. And that would remain our position, Your Honor.
Okay.
Well, a bond pending sentencing, Judge, and you've done it before. I know you have. You've been on the bench long enough. Someone's convicted and you set a sentencing after a PSI, you release them bond pending sentencing. I mean, there's no difference here. You have the authority. The question is whether you will do it.
Okay. I'm not debating whether I have the authority or not. There is some case law that says that I could, if I wished, to give him a bond pending sentencing. But I've pretty much indicated from the get-go on this particular case, based on the way that Mr. Massad failed to cooperate when law enforcement came the last time to arrest him, that I did not feel that letting him out on any bond would be an appropriate thing to do. And I really haven't changed that. What I'm trying to do is facilitate Mr. Massad's cases to move forward. And if you choose to want to start with discovery, and I can reset this for 30 days and ask you where you are. But again, whether it's 2 days, whether it's 3 days, I believe the last case was 2. And so in all of this time that nothing's been going on, it seems to me that discovery should have or could have been done. But I'm not, I wasn't pushing it. And so I'm just telling you that I'm ready to go forward with another trial. If you all want me to I am not going to go forward with sentencing, and I'm choosing not to allow him to be released pending that sentencing. If he's found not guilty on the, practicing medicine without a license, I would sentence him, and the state has already agreed, I believe. They may change their mind, I don't know, but right now they've agreed to some bond rules. But the problem is that there's this case that's in between those two cases. And if he's found guilty on the practicing medicine without a license, he scores mandatory state prison. So it doesn't make any sense to go forward with sentencing when he has another case that put together he's going to go to prison. So he's going to, I'm going to sentence him he's going to begin probation or DOC or whatever the sentence is. I don't really know because I haven't really thought about it. But, you know, I mean, I thought about it, but then I canceled it. So I haven't heard from everybody to what I know. I got your written request, but I don't know what statewide's asking for on their side, and that type of thing. So I hadn't come up with a number in my head. And I looked, the one thing that I did do though, is look at the score sheet, and it dawned on me that that's not probably what I should do if I can have a trial. He's got 4 cases that are level 7s. That's 56 points. If he's found guilty on any one of those, his score sheet immediately puts him into the 24 to 36 month DOC range. That's just a quick calculation with adding one and not guilty on the others, and because I don't know any facts. So I was just saying worst case scenario, at least worst case scenario, if he's guilty of one of the level 7s, his score sheet immediately goes to 2 years or more in prison, maybe 3 years, depending on what happens. So why would I move forward with sentencing where he scores non-state if he's found guilty, he immediately goes to prison? So that's where we are. So I appreciate your position that you would like me either to move forward with sentencing or reconsider his release. At this point, I'm declining to do either. And just so you know, currently in the jail here in Pasco, there is only 14 COVID cases. So we moved through our little, I don't know what you want to call it, blip. But right now in our jail, there's only 14 COVID cases. So there's not, it's not, I think your words were strictly, or in there, you know, we have 14. Our jail's done a really good job. They had a situation where they had a little bit of a run on it, but they, you know, they didn't have any problems after that, and they're down to 14 at this point. And Mr. Massad is not in a COVID pod. So he's safe at this point, as safe as he is in there as he is in his house in Port Richey. So at this point, that's not going to happen.
I tend to disagree with that, but we won't get into that argument. Judge, then why don't we do this? Let's go ahead and give us a November date on the attempted murder. That'll be a month after you'll be trying cases the month before that time. And let's go ahead and tee it up on the one case that we're prepared for. We'll do it in November, find out what happens. If Amanda believes that she can get her witnesses subpoenaed by then, let's go ahead and tee it up, and then we'll try the other case after the first of the year when Bjorn and I are prepared.
Well, if you're asking me to set a trial date for the attempted murder case, is that what you're asking me to do?
Yeah, for November.
That's, first of all, Mr. DeFlaming, I'm not sure you were following me because I said a lot of words. I can't set anything. All I can do is ask Judge Crane if I can set something. He's pretty much already indicated that that was a hard no on the attempted murder case. But I'll go back to him. I need to know how many witnesses. I need to know how many days. I need to know a lot of things. So he didn't think that was possible, but I'll be more than happy to take down the information, reset a pretrial, and get back with the parties if Ms. Beckman thinks that she also would be available for trial sometime after October 26th. Because again, Judge Crane has 100% authority over where, how many, what, where, when, everything. I get to say, please. That's what I get to do. So, Ms. Beckman.
Your Honor, the state will be prepared whenever you call us to trial. I expect that we would present 21 witnesses in our case.
Okay.
I anticipate 3 days, which means it will take 5.
3 days, including jury selection?
Including jury selection, assuming that jury selection doesn't have to be done piecemeal.
So it'd be a whole week?
Yes, I think that would probably be.
Well, because the one thing everybody has to understand is nothing is going to go at the speed it's ever done before. And slow is probably a fast term for how we're going to have to do everything. So everything has to be done in a certain way. And so if 3 days, I would say 5 is a minimum. Okay, go ahead.
Your Honor, does the court anticipate when we conduct jury selection that we would be doing jury selection more along the lines of how Your Honor tends to do capital cases where you're separating the jurors and taking them in smaller batches or individually? Because I did not calculate that in how long I would think jury selection would take.
Well, my courtroom, just so you all know, has been approved based on the administrative plan to have no more than 24 jurors in my courtroom at any time. Now, I'm trying to work with Judge Crane. I haven't been able to get with him. Because I am the grand jury courtroom, also have the ability to put people in my jury box with an extra panel, which would be allowed. I could have up to 21 spaces. That doesn't mean I can fill them all. An additional 21 spaces in my courtroom. So the question might be that I could put 33 maybe people in my courtroom at any one time. That's the most I could have in my courtroom, period. The problem I have with this case is Mr. Massad is kind of well known in this area. And so you're going to have a lot of people that are going to get stricken. We can only bring in probably 50 to 55 jurors downstairs to have my 33 at one time. So it would take multiple days to pick a jury.
I did not consider that in my calculation. I would expect, Judge, that we would take 4 days to present our case in chief and potentially deal with any defense witnesses if they were calling any, and to present arguments to the jury. That would be, I think my conservative guess is to trial presentation. With jury selection, I have no idea.
Okay. And Mr. DeFlaming, how many witnesses does the defense have in that case?
Bjorn, help me out. I think we've listed, I don't know. I think we only have a couple of listed so far, Judge.
Okay.
Now, let me, I don't know whether this is appropriate timing or not, but I'm trying to move this along. Mr. Massad wants it moved along. How about if we do this? Now that I hear that the statewide is going to call 4 or 5 witnesses, which apparently then that's just the alleged victims, maybe one additional witness. So if that's the case, how about giving us a November trial date for the practicing for the practicing medicine judge?
I can't give you a trial date.
Okay, well,
I can tell you that I can go to Judge Crane and tell him that we would like a November date, and then he can get back with me. So what I'm trying to explain to you is there won't be a date today other than the pre-trial.
Okay. Well,
but I understand what you're saying. Like, you think that you might be able to be ready in November, correct?
Based upon what the statewide said, it's a 2-day trial. If they will help us in getting the alleged victims, because some of them are street people, if they will help us in the deposition process of the alleged victims, and they're only going to call 5, I think Mr. Brunbun and I can be ready for that trial. But I understand you have to talk to Judge Crane, and then maybe we could have another hearing. And by that time, perhaps Ms. Peters or Ms. Bach could tell us that they've reached the alleged victims and they'll cooperate.
Okay.
Your Honor, do you have the ability to put together on Zoom? There's the ability of making a breakout room for myself, Mr. DeFlaming, and Mr. Massad to be put in. Can we do that, please?
Sure, I'll try. This will be a first, but I see the breakout rooms here. Assign into room 1 manually. Create room. And then I'm assigning you.
Right, and then we get an invite to accept the invitation, and we just click on that, and it will take us to the room.
Okay, assign. I'm going to assign you, and I'm going to assign Mr. DeFlaming, and I'm not sure how Mr. Massad comes up.
It's JU3709.
Okay, got it. JU3709.
Yep.
Okay. You're there. And open, let's see, I've gotten you into the little thing.
Right.
Now the question is, how many seconds you want?
Like
120?
No, that's 2 minutes. Come on.
I can't, that's the most I can give you.
Give us as much, I think it's minutes. I can't imagine it's.
Mine
seconds.
says set countdown. Oh, that's countdown timer. Sorry. 15 seconds. Sorry. Breakout room closes automatic. 30 minutes, 15 minutes. What do you want?
We won't need more than 5 minutes, but as soon as we're done, we come back. We just leave the room and we come back.
Okay, there, I got that. Now, all I know is how to get you over there. What do I push? Open all rooms?
Should be an invite button. There, we got the invite. We're joining right now. Dennis and Mr. Massad should have a little white box on the screen that says join breakout room. If you click on
So
the
push that.
then we'll take us there.
Dennis is there. All right, they're there. No, they're there. They're off my screen. Are they off your screen? Yeah, they're all.
Judge, I'm sorry I'm late. I had a sentencing where the court interpreter was a little bit late showing up.
No problem. I don't think you missed much.
Okay, Judge, can you hear me?
Yes, I can hear you. Let's see if I have everyone back.
Um,
Dale is
everyone.
not back yet.
I have everyone but Mr.
You know what he might have done? He might have hit, the next bar was leave meeting or leave breakout room. You know him. Judge, all we're going to do is, with his approval, we're only going to.
Oh yeah, he's here, Dennis. He's
Okay.
back. He's back.
Okay, all right.
Okay.
Judge, this is with Mr. Massad's approval. We're just concerned that the longer we wait, the bigger the line is going to be. So we would like you to ask Judge, well, you know, the trial line. So
Oh,
we
the
would like-
line. Okay, I got you.
we would like you to ask Judge Crane to be able to set this trial in January of 2021, and we'll pick a date certain. That's
The attempted murder trial.
yeah, I'm sorry, the attempted murder case.
I can set it in January.
Oh, you can?
Yes, I just can't set it between now and December 31st, but
Oh, let's go ahead and rock and roll. Let's
Okay.
Bjorn, you have your calendar?
Let's do it first week of January, first available trial date in January, and block off a week and a half, please.
But wait a minute now. I want to know when the first is. I'm not going to do it on the second, but I know.
the first is a Friday. So my guess is my first available trial week in January of 2021 would be January 11th, which I need to double check. I don't know if Pauline, or if you're listening, will you check and make sure that's not a holiday? Let's see.
I don't see Amanda. Are you there, Amanda? All I have is a black screen for Amanda. Is she on?
Amanda's in the courtroom.
Who is Amanda?
Who's Amanda?
Oh, I'm sorry. Samantha.
Samantha Beckman?
Samantha.
Yes.
Miss Beckman's in the courtroom with me.
Oh, okay. Because it has her name up here, but a blank screen.
Yeah,
Amanda's here too.
when you're in my courtroom, you can't have any audio on or it gives me feedback. So they come on with just the pictures and no audio.
Sorry, I meant Samantha.
That's okay. Okay, January 11th is fine. I can set, Ms. Beckman,
Your Honor.
what do you think?
Your Honor, we will be ready for trial.
All right, we will set January 11th of 2021 for trial in case number 19 CF 1155. And I'll set a pre-trial on the all three. I'll set on both of the open cases a pre-trial. I have November 23rd at 1:30, if you all think that would work for you, both sides.
That's fine for the state, Your Honor.
Ms. Beckman?
Yes, Your Honor. I did want, the following Monday would be the holiday, the
Correct.
18th. So just if Your Honor would give us the 2 weeks for a worst case scenario, that would be great.
Yeah, that's what I intended to do. I'm
Thank
gonna
you, Judge.
we'll have the Monday off so that if the jury's picked, if we go on, they'll have Saturday, Sunday, Monday off.
Okay.
And then we'd start again on Tuesday. So I'm gonna book from January 11th through January 22nd for trial. That'll be that's 9 trial days.
That's good.
Mr. DeFlamming, you think that'll be enough?
Yes, that'll work.
Okay, and I'll also set a sentencing. I'll set the sentencing, which is 19 CF 1580. I'll reset that for January 11th of 2021. I'm not saying he'll be sentenced that day. I just keep it on the calendar to go along with the other cases.
And when did you say the pretrial was in November? November what?
November 23rd at 1:30.
Gotcha. Okay.
And if that's probably, you can appear in person or via phone. That's a Monday. So if you want Mr. Massad to appear for that pretrial, you can call me ahead of time. I'd have to do it a little different because
Gotcha.
I'd have to do a Zoom pretrial and we just rearrange it. So we do it on the end of that calendar. So I can do it that day, but it'd be more like at 3:00 by Zoom, if that's the way you want to do it. But you can appear in person. He won't be brought over from the jail though yet.
Okay.
Okay, so I don't know if he wants to be here or not. So just let me know, okay?
We will. Yep.
Anybody else need anything else from me? Statewide, state, anybody?
No, Your Honor.
All right, then we will see you all back in November, okay?
Okay, all right.
Thank you.
Thank
Your
you.
Honor.
Bye-bye.
Bye-bye.